Public versus private. A very important subject is the division of legal authority between public and private rights. On this subject, the U.S. Supreme Court held a private person cannot make constitutions or laws, nor can he with authority construe them, nor can he administer or execute them. If you can't execute them, then you also can't enforce them against anyone else. Some people might be tempted to say that we all construe them against the private person daily, but in fact, we can't do that without being a public officer within the government. The reason why states are bodies, politic, and corporate is simple. Just as a corporation is an entity that can act only through its agents, the state is a political corporate body, can act only through agents, and can command only by laws. See also Black's Law's Dictionary. Body politic or corporate. A social compact by which the whole people covenants with each citizen and each citizen with the whole people, that all shall be governed by certain laws for the common good. As a body politic and corporate, a state falls squarely within the dictionary's acts definition of a person. If we do not enforce the law as a private non-resident human, we are criminally impersonating a public officer in violation of 18 U.S. Code 912. Other U.S. Supreme Court sites also confirm why this must be. All the powers of the Gov, including all of its citizen civil enforcement powers against the public, must be carried into operation by individual agency, either through the medium of public officers or contracts made with private individuals. We are of the opinion that there is a clear distinction in this particular between an private individual and a public corporation, and that the latter has no right to refuse to submit its books and papers for an examination at the suit of the state. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business, or to open his doors to an investigation so far as it may tend to incriminate him. He owes no such duty to the state, since he receives nothing, therefore, beyond the protection of his life and property. His rights are such as existed by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law, and in accordance with the Constitution. Among his rights are a refusal to incriminate himself, and the immunity of himself and his property from arrest or seizure except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. Upon the other hand, the public corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises, and holds them subject to the laws of the state and the limitations of its charter. Its powers are limited by law. It can make no contract not authorized by its charter. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation. There is a reserved right in the legislation to investigate its contracts and find out whether it has exceeded its powers. It would be a strange anomaly to hold that a state having chartered a corporation to make use of certain franchises could not, in the exercise of its sovereignty, inquire how these franchises have been employed and whether they have been abused, and demanded the production of the corporate books and papers for that purpose. The defense amounts to this, that an officer of a corporation which is chartered with a criminal violation of the statute may plead the criminality of such corporation as a refusal to produce its books. To state this proposition is to answer it. While an individual may lawfully refuse to answer incriminating questions unless protected by an immunity statute, it does not follow that a corporation, vested with special privileges and franchises, may refuse to show its hand when charged with an abuse of such privileges. You must therefore be an agent of the government, and therefore a public officer in order to make constitutions or laws or administer, execute, or enforce either. Here is more proof. A defendant sued as the wrongdoer who seeks to substitute the state in his place or to justly by the authority of the state or to demand on the ground that the state has adopted his act and incinerated him cannot rest on the bare assertion of his defense. He is bound to establish it. The state is a political corporate body and can act only through agents and can command only by laws. It is necessary, therefore, for such a defendant, in order to complete his defense, to produce a law of the state which constitutes his commission as its agent and a warrant for his act. By act above, they implicitly also include enforce. If you aren't an agent of the state, they can't enforce against you. Examples of agents or public officers of the Gov include the following: person 26 U.S. Code 7701A1, individual 26 CFR 1441 1C3, taxpayer 26 U.S. Code 7701A14, driver under the State Vehicle Code, withholding agent 26 U.S. Code 7701A16. The government thus lays a tax through the government instrumentality public office of the company, a Fed and not state corporation, upon the income of a non-resident alien over whom it cannot justly exercise any control, nor upon whom it can justly lay any burden. United States versus Erie R. Company. So how do you obey a law without executing it? We'll give you a hint: it can't be done. Likewise, if only public officers can administer, execute, or enforce the law, then the following additional requirements of the law are unavoidable and also implied. 1. Congress cannot impose duties against private persons through the civil law. Otherwise, the 13th Amendment would be violated and the party executing said duties would be criminally impersonating an agent or officer of the government in violation of 18 U.S. Code 912. 2. Congress can only impose duties upon public officers through the civil statutory law. 3. The civil statutory law is a law for government and not private persons. 4. Those who enforce any civil statutory duties against you are presuming that you occupy a public office. You cannot unliterally elect yourself into a public office in the Gov by filing out a government form, even if you consent to volunteer. 6. Even if you are a public officer, you can only execute the office in a place expressly authorized by Congress per 4 U.S. Code 72, which means only in the District of Columbia and not elsewhere. Title 4, Chapter 372, Public Offices at Seat of Gov. All offices attached to the seat of Gov should be exercised in the District of Columbia and not elsewhere, except as otherwise expressly provided by law. 7. If you are construing, administering, or executing the laws, then you are doing so as a public officer, and you are bound and constrained in all your actions by the Constitution like every other public officer while on official business interacting with private humans. The public records exemption to the hearsay exemption rule, Fed Rule of Evidence 8038 applies. Everything you produce in the process of construing, administering, and executing the laws is instantly admissible and cannot be excluded from the record by any judge. If a judge interferes with the admission of such evidence, he is interfering with the duties of a coordinate branch of the Gov in violation of the separation of powers and criminally obstructing justice. If you would like to study the subject of private property and its protection further after reading the following subsections, here is private versus public property rights and protection, separation between public and private, legal remedies for the protection of private rights, and sovereignty and freedom. Introduction. In order to fully understand and comprehend the nature of franchises, it is essential to thoroughly understand the distinction between public and private property. The following subsections will deal with this important subject extensively. In the following subsections, we will establish the following facts. 1. There are two types of property. Public property. This type of property is protected by the civil law. And private property. This type of property is protected by the common law. Specific legal rights attached to each of the two types of property. These rights in turn are also property as legally defined. property, that which is peculiar or proper to any person, that which belongs exclusively to one, in the strict legal sense, an aggregator of rights which is guaranteed and protected by the government. The term is said to extend to every species of valuable right and interest, more specifically ownership, the unrestricted in a legal way, to possess it, to use it, and to exclude everyone else from interfering with it. The dominant, dominion, or indefinite right of use or disposition which one may lawfully exercise over peculiar things or subjects. The exclusive right of possessing, enjoying, and disposing within the highest right a man can have to anything, being used to refer to that right which one has hands to intermit goods or chattel, which no way depends on another man's courtesy. The word is also commonly used to denote everything in which it is the subject of ownership, corporeal or incorporeal, tangible or intangible, visible or invisible, real or personal, and everything that has an exchangeable value or which goes to make up wealth or estates. It extends to every species of value, right, of interest, and excludes real and personal property. Oh, that's crazy. Easements, franchises, and incorporeal inheritments, and includes every invasion of one's property rights by actionable wrong. Human beings can simultaneously be in possession of both public and private rights. This gives rise to legal persons, public and private. The civil law attaches to the public person, the common law and constitution attach to and protect the private person. This is consistent with the following maxim of law. When two rights, public right versus private right, occur in one person, it is the same as if they were two separate persons. Brouwer's maxims laws. That the purpose of the Constitution and the establishment of the government itself is to protect exclusively private rights. We hold these truths to be self-evident, that all men are created equal and they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these exclusively private, Lord-given rights, governments are instituted among men, deriving their just powers from the consent of the governed. The very first step in protecting private rights and private property is to prevent such property from being converted to public property or public rights without the consent of the owner. In other words, the very first step in protecting private rights is to protect you from the gov's own theft. Obviously, if a gov becomes corrupted and refuses to protect private rights or recognize them, there is absolutely no reason you can or should want to hire them to protect you from anyone else. The main method for protecting private rights is to impose the following burden of proof and perception upon any entity or person claiming to be gov. All rights and property are presumed to be exclusively private and beyond the control of gov or the civil law unless and until the gov meets the burden of proving, with evidence on the record of the proceeding, that 1. A specific formerly private owner consented in writing to convert said property in public property. 2. The owner was domiciled on Fed territory not protected by the Constitution, therefore had the legal capacity to alienate a constitutional right or relieve a public servant of the fiduciary obligation to respect and protect the right. Those domiciled in a constitutional but not statutory state and who are citizens or residents protected by the Constitution cannot alienate rights to a real de jure government. If the gov refuses to meet the above burden of proof, it shall be conclusively presumed to be operating in a private corporate capacity on an equal footing with every other private corporation, and which is therefore not protected by official, judicial, or sovereign immunity. Oh, interesting. That the ability to regulate exclusively private conduct is repugnant to the Constitution, and therefore such conduct cannot lawfully become the subject of any civil statutory law. Under basic rules of construction, statutory laws enacted by legislative bodies cannot impair rights given under a constitution. Interesting. That the term person, persons, individual is used within the civil statutory law by default imply public persons and therefore public offices within the gov and not private human beings. Yeah, that part. Alright. I think I'm gonna stop right there. All such offices are creations and franchises of the gov and therefore property of the gov subject to exclusive control. That if the gov wants to call you a statutory person or individual under the civil law, then you must volunteer or consent at some point to occupy a public office in the gov while situated physically in a place not protected by the U.S. Constitution and the Bill of Rights, namely Fed territory. In some cases, this public office is called a citizen or resident. If you don't volunteer, they are sexually exercising unconstitutional eminent domain over your private property. Keep in mind that rights protected by the Constitution are private property. That there are very specific and well-defined rules for converting private property into public property and offices, and that all such rules require your express consent, except when a crime is involved. That if a corrupted judge or public servant imposes upon you any civil statutory status, including that of a person or individual, without proving with evidence that you consented to that status and had the capacity to lawfully consent at the time you consented, they are violating due process of law, imposing involuntary servitude, stealing property from you. We call this theft by presumption, kidnapping your identity and moving it to a Fed territory, instituting eminent domain over exclusively private property. That within the common law, the main mechanism for preventing that conversion of private property to public property through government franchises are the following maxims of law. These maxims of law mandate that all gov must protect your right not to participate in franchises or be held accountable for the consequence of receiving a benefit you did not consent to receive and are regarded as an injury rather than a benefit. No one is obligated to accept the benefit against his consent, but if he does not dissent, he will be considered as assenting. Anyone may renounce a law introduced for his own benefit. To this rule, there are some exceptions. Brower's Law, maxims of law. For an example of how this phenomenon works in the case of the Internal Revenue Code, subtitles A and C, trade or business franchise. See why your gov is either a thief or you are a public officer for income tax purposes. Alright, I'm getting off now.